Welcome to This Explainer. Today we are conducting a complete, top-to-bottom autopsy on the traditional digital agency model. For decades, the agency world has basically operated in this highly permissive, almost Wild West regulatory environment. But that era? Yeah, it's abruptly ending. We're going to examine exactly why the standard operating procedures of creative and media agencies are triggering a systemic, legally driven structural collapse in 2026, and what that actually means for the future of digital marketing.
Okay, here's our roadmap for This Explainer. First, we'll uncover the broad legal demise of agencies. Then, we'll break down three specific operational traps: the contract conflict trap, pixel tracking becomes wiretapping, and principal media arbitrage exposed. And finally, we will wrap up with the agency survival rules for 2026.
Section 1. The 2026 Digital Agency Collapse.
So here is the absolute crux of the issue. We are officially moving out of that permissive ad tech era and slamming right into a very acute, highly regulated legal reality. We're talking about three massive threats converging all at once. You've got strict new AI transparency laws, aggressive class action lawsuits that are actually weaponizing old wiretapping statutes, and explosive whistleblower exposures hitting media buying. You simply can't rely on the old playbooks anymore. The old way of operating isn't just bad practice now, it's a massive company-ending legal liability.
Section 2. The contract conflict trap.
Let's talk about how incorporating those incredibly powerful generative AI tools into everyday workflows is actually causing agencies to inadvertently breach their own long-standing client contracts. Starting January 1, 2026, transparency laws, like California's SB 942, changed the entire game. We're looking at insanely steep civil penalties. Imagine getting hit with a $5,000 fine per day per violation, just for failing to properly disclose AI-generated content. If you're an agency producing content for clients with a large California audience, that kind of opacity is now a phenomenally expensive liability.
And this right here perfectly illustrates the trap. Think about your standard legacy master services agreement. It promises a work-for-hire arrangement, right? Full intellectual property transfer of all assets directly to the client. But under current law, purely machine-generated AI outputs generally cannot be copyrighted. So, the absolute second you use an AI tool under one of those legacy MSAs, you are promising to transfer ownership of an asset that you legally don't even own. That puts you in immediate breach of contract. An algorithmic era MSA, on the other hand, specifically assigns non-copyrightable outputs and explicitly allocates the risk for using these AI tools.
To dodge those massive fines, agencies are facing a huge downstream transparency problem. The laws now require visible manifest disclosures. Think of permanent, watermarked labels identifying content as AI-generated. But they also require latent disclosures. That's the embedded system metadata that travels invisibly with the file. Now, here's the scary part. Say you deliver a perfectly compliant file, but your client strips out that metadata before they hit publish. Who gets the fine? Without updated contracts that enforce strict metadata preservation duties, the agency could easily be left holding the bag for a client's mistake.
Section 3. Pixel tracking becomes wiretapping.
Shifting gears from AI to privacy, we're seeing decades-old laws being aggressively weaponized against totally standard marketing analytics. We all know what a tracking pixel is, right? It's just a snippet of code embedded on a web page to transmit user data for analytics and retargeting. But every day, foundational tools like the Meta Pixel, the TikTok Pixel, or even Google Analytics are now being challenged as unauthorized wiretapping under laws like the California Invasion of Privacy Act. Plaintiffs' attorneys are literally arguing that transmitting user interactions without prior consent is an unlawful interception of electronic communications. Crazy, right?
And listen, this is definitely not theoretical. If your agency manages websites in sensitive industries, you are standing right on the front lines. Healthcare sites handling clinical services or telehealth, financial services dealing with fintech or tax prep, and heavy e-commerce brands, they are all highly targeted for these class action lawsuits. The unconsented data collection from these pixels puts the client and the agency who configured and deployed the technology directly in the crosshairs of aggressive litigation.
The legal trap here is entirely about consent timing. It all comes down to fractions of a second. It is no longer enough to just have a generic cookie banner floating somewhere at the bottom of the page. If your pixel fires and transmits a visitor's IP address or their browser data or behavioral interactions before that user explicitly clicks accept, plaintiffs will argue the illegal interception has already happened. The new rule is absolute: zero data transmission until affirmative opt-in consent is firmly granted.
Section 4. Principal media arbitrage exposed.
Let's look objectively at a massive financial scandal that has been absolutely rocking media procurement and severely damaging the trust between advertisers and their agencies. While fighting a whistleblower suit, the massive holding company WPP had to file highly sensitive internal data to the public court record. This internal report, called Project Claridge's, showed a shockingly stark disparity. Google, which generated $2.3 billion in annual U.S. billings for the agency, used a microscopic 0.51% of the agency's proprietary rebate-generated inventory. The top 30 clients combined, they represented $13.5 billion in billings, but used only 5% of that inventory. So, let's unpack why that is such a massive scandal. A $100 million lawsuit from former executive Richard Foster alleges that the agency systematically retained up to $2 billion in volume rebates over 5 years, rather than returning those benefits to the actual advertisers. The allegations state that the agency generated $1 billion in revenue from principal media trading, money that went straight to its own bottom line, while the clients who supposedly opted in saw virtually zero benefit from doing so.
The core of this allegation is a severe systemic crisis of trust. The massive budgets of the largest clients were leveraged to hit volume thresholds, which triggered all this cheap rebate inventory. But a staggering 97.4% of that proprietary inventory was left completely unused by those top clients. Instead, it was allegedly marked up and resold to smaller, less sophisticated clients as principal media. So the very clients funding the entire model weren't the ones benefiting from it.
Section 5. Agency Survival Rules for 2026.
So how do we actually navigate this highly scrutinized, legally perilous landscape? Well, to survive the collapse, you must execute these 3 exact steps. 1. Build a verified first-party data architecture. You have got to stop relying on opaque third-party data and build your own transparent methodologies. 2. Implement zero-consent tag management. Your pixels must be strictly technically blocked until opt-in consent is explicitly given by the user. And 3. Adopt AI-updated master services agreements. Those legacy contracts you're using, they are ticking time bombs.
Drilling down into those contracts, your 2026 clauses must be absolutely ironclad. You need explicit AI disclosure and consent, right alongside tightly defined duties for metadata preservation, so you aren't held liable if a client carelessly strips your tags. You also must have non-copyrightable IP ownership allocation, bilateral liability limits to prevent catastrophic, business-ending lawsuits, and structured audit rights. You have to clearly, explicitly define exactly who is liable if an AI tool infringes on IP, if it hallucinates, or if it fails regulatory compliance post-delivery.
I want to leave you with this final, critical thought to help evaluate your own risk exposure. Is your agency truly built for the algorithmic era, or are you already operating in breach of contract? The era of opaque, non-compliant digital marketing is officially, permanently over. Surviving 2026 means leaning hard into transparency, totally owning your compliance, and proving your real value without relying on hidden arbitrage. Thanks for joining me for this explainer, and good luck navigating these massive shifts ahead.